All right, welcome to Marriage Counselling and Management course. This is Module 7, and we'll focus on divorce, separation, child custody, and how to administer will. Okay? So some marriages cannot or should not continue. It's not every marriage that should continue. So skilled marriage counselors should help couples to navigate divorce well. You can help them to navigate divorce not as failure, but as a difficult but sometimes necessary resolution that can help to protect children, assets, and even their future well-being. So it is important for counselors to make these couples to know that divorce is not planned, but sometimes it can come along the way. It can become a difficult decision that can be arrived at to protect children and also ensure their future well-being. Okay, so in this module, we'll cover the cause and effect of divorce and separation, how to properly finalize divorce, then fighting for child custody during separation and divorce, and how to administer will and execute it in Nigeria. Okay? So, divorce is not the enemy. It is poorly managed divorce that is the enemy. So, as a skilled counselor, you have to make the couples know that a poorly managed divorce can destroy families, it can traumatize children, and even leave a lasting emotional and financial wreckage. So, but a well-managed divorce can allow both parties to rebuild their lives and co-parent, effectively. Now, what are even the common causes of divorce in Nigeria? Maybe throughout this course to this point, you should be able to picture the common causes of divorce in Nigeria. For instance, talk about extended family interference, then infidelity, which is infidelity is just known as a common ground for divorce. Sometimes it's culturally tolerated for men, but not for women. If women go into infidelity, culture do not permit it at all in Nigeria. Then financial conflict, when there is chronic disagreement or there is a hidden debt, that can lead to divorce. Communication breakdown too can also lead to divorce. And domestic violence. Domestic violence is a legally recognized ground for divorce. Then let's talk about infertility. Infertility is actually the major cause of divorce, especially where there is a cultural pressure for children. Cultural pressure or demand for children is intense. Addiction is also another ground for divorce. Okay, some persons divorce or seek for divorce because their spouse is addicted to either gambling or even to alcohol, as the case may be. Okay, but let's talk about the effects of this divorce on adults and children. Okay, divorce is one thing, but it has a lot of ripple effects. On adults, it can cause emotional. It can lead to have emotional effects such as grief, anger, shame, relief, depression, and even identity confusion. It can also have practical effects on the adults, such as reduced household income, increased expenses, and even asset division. Okay? Even on the health, higher rates of cardiovascular disease, you are prone to weakened immune function and increased mortality in first years post-divorce, especially for men. So there's also emotional distress for children. It can affect their academics, it can affect their behavior, and even it can lead to social withdrawal. So you have to, protective factors for children can include low conflict between parents, continued involvement of both parents, and consistent routines across households. Now, but when divorce benefits children, for instance, in high conflict marriages with domestic violence or severe hostility, children often fare better after divorce. But in a family where there is low conflict, after divorce, it can still impact the emotional state of the children. So staying together for the children is only beneficial. Mark it, only beneficial when the marriage is reasonably functional and low conflict. Okay, but high conflict marriages harm children a great deal. We need to know the difference between separation and divorce. Some persons use these terms interchangeably. Divorce is different from separation. Separation can be judicial separation. Okay, that is legal status that allows couples to live apart while remaining legally married, but they are living apart. That's what we call separation. Neither of the party may remarry. Okay, it may be a trial period or a permanent arrangement for religious reasons or a step towards divorce. That is separation. But for divorce is actually the dissolution of the marriage. That is the legal termination of a valid marriage. And after decree absolute, both parties are free to remarry. Okay, so statutory marriages can only be dissolved by a high court if it's a statutory marriage. So separation does not automatically lead to divorce, but a separate court petition is required. So many clients, confuse these terms. So as a good marriage counselor, you have to clarify these terms early. You have to tell them that separation is a status, but divorce is an event that ends the legal marriage. Okay? Now, grounds for divorce under Nigerian law. We talk about adultery, unreasonable behavior, separation with consent or separation without consent, failure to consummate, mental illness, and even imprisonment. So these are grounds for divorce under Nigerian law. Now, what are the step-by-step statutory divorce procedures? First, meet with a family law lawyer. Okay, so counselors can refer. Do not give a legal advice. A counselor is not a lawyer. So as counselors, you can refer, okay, to a legal practitioner. Then 2, attempt reconciliation. Court must be satisfied. No reasonable likelihood of reconciliation before you go into divorce. Okay, then after that, you file petition with High Court, including the grounds, the reasons for the divorce, then including children's details and requested order. Then the 4th step will be service of petition on respondent. This is when they issue formal notification by court, bailiff, or process server. Then you now move to respondent file response, which can take 21 to 30 days or default. So this is contested versus uncontested. Okay. Then undefended or defended hearing. This is when evidence is brought before the judge. Then after that, you now move to decree nisi, which is called provisional decree. So this is where court sees no reason not to dissolve. Waiting period for at least 3 months. Okay? If the court sees that there is no genuine reason to dissolve this marriage, they can give a waiting period for at least 3 months. Then after that, we now move to decree absolute, which is the final decree. This is where the marriage legally ends and both parties are free to remarry. So these are the statutory divorce procedures that if you want to seek divorce, these are the procedures to follow. Okay, let's talk about customary or an Islamic divorce. Not all divorces are equal under the law. For customary divorce, dissolves customary marriage. Okay, bride price will be returned, family elders will be called. So it does not dissolve a statutory marriage. So, but in Islamic divorce, which is talaq, husband pronounces talaq, wife may initiate khul. Okay, but it should be registered with local government or Sharia court. But this is a critical advice you need to give to clients. If they had both a traditional wedding and a statutory, the statutory marriage must be dissolved through the High Court. Okay, then the customary or Islamic divorce alone has no legal effect on the statutory marriage. Now, what is the consequence? Without statutory divorce, remarriage is bigamy, and property custody rights remain governed by statutory laws. So this is a common source of confusion. Many couples think their traditional divorce ends everything. It does not. So you need to advise clients to seek court or legal intervention. Now let's talk about child custody. Okay? Now, legal custody simply means right to make major decisions with respect to education, healthcare, and religion. Okay? So there's what we call physical custody. This is where the child lives and the day-to-day care of the child. So please, anyone you have to choose must be in the best interest of the child. Now, factors to be considered should include child's age, child's wishes, okay, parents' ability to care for child, parents' moral conduct, and child's existing attachments. So you should avoid disrupting established bonds. Then, willingness to support child's relationship with the other parent. Then, if there is a history of domestic violence or child abuse, this is a very powerful factor. So no parent has an automatic right to custody. The child's welfare is the court's only guide. Okay? So, let's talk about child support and parenting plans. Now, financial support paid by non-custodian parent can be based on the income of the parents, the child needs like school fees, health care, food and clothing, then custodial parents' income and amount of parenting time each parent has. Okay? So you have to have a parenting plan on how you will parent your child. Okay? But mediation is preferred over litigation. It is cheaper, it is faster, it's less damaging to children and family resources. So a good parenting plan prevents endless argument. Okay? Mediation helps parents to create their own plan instead of having a judge impose one on them. So don't allow judge to impose one on you. You know yourself, you know your situations, so you plan within your means, you plan together just to ensure that these children are safe. Okay? So now let's talk about will. Why every married person needs a will. Dying without a will, take note, will create chaos. So without a will, your spouse may not receive your entire estate. Without a will, under administration of estate laws, for instance, spouses get 1/3, children get 2/3, until in trust until adulthood. But under some customary laws, widows may receive nothing. So court decides guardianship of minor children, and this may not align with your wishes. So family conflict is almost guaranteed. But if you have a will, you direct who gets what. That is what a will does for you. You direct who gets what, and that protects your spouse and children. You name guardians for minor children, and you avoid or reduce family conflict. You can exclude unintended beneficiaries too. But this, your will be valid. So valid will requirements in Nigeria can include that you must be 18 plus to sign a will. You must have sound mind. That is your mental state. It must not be done by force. It must be voluntary. It must be written down and signed by the testator. 2 witnesses who are not beneficiaries should be part of it. Many married people assume their spouse inherits everything automatically. No, this is dangerously wrong. A will is an act of love and an act of responsibility. Okay? Now, this module equips you to guide clients as a marriage counselor. This is what the module does, to equip you to guide clients through endings as well as beginnings. Do not shy away from divorce. Do it well. Divorce is not a failure. Poorly managed divorce is the failure. So competent counselors help clients navigate the solution with dignity, protect children from adult conflict, and plan for the future, including the future after death, through proper will administration. Thank you.